This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
Good afternoon, Mr. DePascali.
Good afternoon.
Mr. Perez was a computer programmer, true?
Yes.
When you learned there was going to be an SEC audit, you got your marching orders from Mr. Madoff as to how you were going to deal with that audit. Is that correct?
Yes.
And after that, you went to speak to Mr. Perez because you needed him to do certain work for that audit, correct?
Correct.
Now, that type of meeting where you're telling him what he needs to do, Mr. Madoff didn't attend that kind of meeting, correct?
No.
And one of the things you needed Mr. Perez to do was to create a subset of Madoff accounts, some 20 or so, that Mr. Madoff had instructed you were the accounts he was going to show the SEC, correct?
Correct.
So you created a cover story that would make Mr. Perez comfortable as to why records were being created for only 20 or so clients of the company. Isn't that right? Yes or no?
Yes.
In essence, you told Mr. Perez that for this audit, he was doing nothing wrong. There was nothing wrong with subsetting, creating a subset of clients, because that's all that the SEC had asked for, correct?
Yes.
You certainly didn't tell him that the purpose of the exercise was to fool the SEC. You did not tell him that, correct?
I did not.
And in misleading him in that way, do you agree with me? You were manipulating him.
Yes.
For your own purposes, correct?
For Bernie's purposes, yes.
For your purposes in implementing Bernie's plans, true?
True.
You were his boss, true? One of his bosses.
That is correct.
It was his job to follow your orders, correct?
Correct.
You were his friend, true?
True.
Isn't it correct, Mr. DePascali, that you lied to him about what the SEC had requested in the audit? Yes or no?
Yes.
You did that so that he would be comfortable doing the work, true?
My intention was to make him comfortable.
Isn't it a fact, Mr. DePascali, that you were manipulating him in order to have him participate in what you knew to be a massive fraud without him knowing it? Wasn't that your intent, yes or no?
Yes.
Didn't you think, as his boss and as his friend, you owed him better than that?
During the short time frame when I had to make that decision, that didn't cross my mind.
As you sit here today and look back on that episode that we are discussing now, do you agree that as his boss and as his friend, you owed him better than that?
Yes, certainly.
So looking back on it now, you agree he deserved better than what you did to him, correct?
Yes.
The force of logic, because although I didn't have the witness committed to the answer to most of those questions, by the force of logic, I knew he had to say yes. The only fact that I knew he was committed to was that he had lied to him, lied to Mr. Perez about the purpose of the audit. But I knew that if he lied to him, therefore he was manipulating him. Therefore, he was abusing their trust. Therefore, he was abusing his position as his boss. That was all just the force of logic, because if the witness had said, no, I wasn't manipulating him, it would not have made any sense because he's lying to him to get him to do something. So I knew through that reasoning process that the witness had to either adopt where I was taking him or look like a liar. So I was comfortable going there.
And Larry, based on this cross-examination, did you use any of the testimony in your closing argument to argue that your client actually didn't know about the scheme?
The testimony you just read was one of the centerpieces of my closing argument. That was the essence of my opening statement, my cross-examination, and my closing argument was that Mr. Perez, my client, was lied to about why he had to do everything at Madoff Securities, and he never learned the truth. So it was that was critical testimony for me, and very, very powerful help to my case. Now, I will say that Mr. Perez was actually convicted after trial. However, what was fascinating is that although we lost the trial, the judge got the point that he was in fact lied to and manipulated. And at the end of the day, when he came up for sentencing, the government argued that he was a knowing participant for 20 years, and they advocated that he should get 14 years in prison. And we successfully, through the trial, the judge saw that was an exaggeration, and she expressly found at sentencing that he had only been a knowing participant for 2 years, not 20 years, because he had been lied to. And she sentenced him to 2.5 years in prison instead of the 14 years that the government was asking. So in a roundabout way, the cross-examination was successful, even though it did not result in an acquittal. The second demonstration, as I said earlier, this is because we had this problem where his testimony was helpful, but then he had the last 2 years, he said some damaging events occurred, which is why we had to also suggest to the jury that it couldn't rely on his testimony at all as to what had happened at that time period. So this is a pure credibility cross-examination. I had more ammunition than usual because Mr. DePascali had to admit that he had led a life of fraud because he had pled guilty to assisting Madoff in this fraud for over 20 years or 30 years or so. And he had also pled guilty to committing perjury before the SEC, Securities and Exchange Commission, in order to help Madoff cover up the fraud. So those are facts that he could not back away from and that I had in my ammunition belt. And what I used those facts and I tried to spread them out and stretch them out as far as I could. Would you agree with me, Mr. DePascali, that during the course of your 30 years at Madoff Securities, many individuals placed their trust in you, correct?
That is correct.
And as to many of those individuals, would you agree that you violated their trust by not telling them the truth, correct?
That is correct.
In fact, you did that on virtually a daily basis for 30 years. True?
Yes.
Do you agree with me that your track record for trustworthiness is not so good?
As it pertains to clients, I agree.
Well, the clients aren't the only individuals whose trust you violated. Isn't that right? Yes or no?
I can't think of a situation where I did violate someone other than a client's trust. Not sure.
As you sit here today, you can't think of another situation in your 30 years at Madoff Securities where you violated the trust of an individual other than a client. Is that your testimony to this jury?
Not at the moment.
Well, would you agree with me, just by way of example, that when you committed perjury before the SEC, you violated the trust of the attorneys taking that testimony? True?
I do agree with that.
When you lied to regulators on a regular basis in your capacity as a Madoff Securities employee, you violated their trust. True?
I agree with that.
When you lied to Madoff employees, do you feel you violated their trust?
I do.
As you sit here today, do you consider yourself to be an honest man?
As I sit here today, I undoubtedly consider myself to be an honest man.
And is that because you've undergone some kind of moral transformation? Yes or no?
Yes.
Could you pinpoint for us, as best you can, when, what date, what time did you undergo that moral transformation? Can you pinpoint it?
I cannot.
Now, you started your testimony here today by taking an oath. Do you recall that?
I do.
The oath was to the effect, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Do you recall that?
I do remember that.
Is that oath important to you?
Yes, it is.
Is it a sacred duty in your mind?
Yes, it is.
Would you be willing to violate that oath in this courtroom if you felt it was in your best interest to do that?
No.
Am I correct, Mr. DiPasquale, that you have not always felt that way about the oath? True?
That is correct.
Is it fair to say that before this moral transformation that you just mentioned, things like oaths didn't mean anything to you, correct?
Yes.
In fact, during that time period, you were willing to violate the oath if it served your purposes.
Yes.
True? Now, I'd like to direct your attention to January 26th, 2006. Do you recall what that day was?
No.
Would you accept my representation? That was the day that you committed perjury before the SEC.
That meeting was in that time frame, so yes.
Now, before that SEC testimony began, you were administered an oath as well, correct?
I was.
It was pretty much the same oath that you took in this courtroom today, correct?
Yes.
And on that day, you violated that oath, correct?
True.
You did that in front of 3 lawyers from the Securities and Exchange Commission, true?
I think there were 2 lawyers and 1 SEC staff person.
There were 3 representatives of the Securities and Exchange Commission, correct?
Correct.
And you understand that the SEC is a part of the federal government, correct?
I do.
Just as the United States Attorney's Office is a part of the federal government, correct?
It is.
And just as the FBI is a part of the federal government, correct?
Yes.
And when you were before the SEC under oath, you tried to anticipate the questions, right?
Yes.
You tried to think ahead of what answers you could give to respond to those questions, correct?
That is correct.
You basically practiced your lies, true?
Yes.
You did that so that you would appear to be sincere, correct?
Yes.
So you would appear to be honest, correct?
Yes.
You would appear to be telling the truth, the whole truth, and nothing but the truth, correct?
Correct.
But in fact, your testimony was entirely false, true?
Correct.
You were completely dishonest, true?
Yes.
You were not forthright at all.
To most of their questions.
Do you agree that the commission of perjury before the SEC was a very serious crime?
I do.
How did it feel to commit perjury before the SEC?
It did not feel wonderful.
Were you scared?
Somewhat.
Did you try to create the impression in the room that you were not scared, but that you were calm and had absolutely nothing to be nervous about?
I might have tried to give that impression, yes.
Isn't it a fact that you tried to give that impression because that would make it more likely that you would be successful in persuading them that you were actually telling the truth when you were not, correct?
Yes.
Am I correct, sir, that you prepared for your commission of perjury that day? True?
Yes.
You talked it over with Mr. Madoff. True?
Among others, yes.
All that was to further your goal of deceiving them, correct?
It was.
To throw them off the trail of the truth, correct?
It was.
All so that the fraud in which you were a major participant would go undetected, correct?
Yes.
So that the scam could continue, true?
Yes.
So that you could continue making money from the scam, true?
Partially, yes.
No further questions. It is a good illustration of the use of the force of logic for your questions, and for that you really can ask questions that you don't actually know the answer to because there's no good answer for the witness. So when I asked him questions like, did you have a moral transformation? I didn't care what his answer was because I had a plan either way. If he said he didn't have a moral transformation, well, then he's completely cooked because he's still a liar. But if he claimed he did have a moral transformation, I knew that I could attack that as just not believable after a life of that much lying. So there were a number of questions where I didn't know the answer, but I knew I couldn't lose. For example, how did it feel to commit perjury to the SEC? I had no prior statement as to how it felt to commit perjury to the SEC. But I knew in my mind that there was no good answer for him. If he said it felt fine, well, then he's just a kind of sociopath who doesn't even care if he's lying. And if he said it was a problem for him, then I knew that I was going to go the other route, was to show that even though it was a problem for him, he was able to be an actor and pretend he was calm, cool, and collected. And so I had a path either way. And I was drawing the parallel that, of course, this is what he's doing in front of this jury, is inside his mind, he has his own agenda, he has his own fears, he has his own motivations, but he's making it appear to this jury that he's calm, cool, collected, and truthful, just as he had done at the SEC.
Did you use this portion of the cross-examination in your closing argument, and if so, how?
Yeah, of course, I did use it. It was a powerful part of the cross-examination, and I used it again to argue that as to those aspects of his testimony that were damaging to my client, that he could not be relied on, that he couldn't be believed, that his testimony certainly wasn't believable beyond a reasonable doubt, because he had led this life of lies, because he lied to regulators, customers, employees, because he committed perjury before the SEC, and because he was a professional liar. He was practiced at it, he was gifted at it. And so the jury had to see him as a gifted liar.
Okay, so I will just say for those listening that the cross-examination is obviously much longer than the two excerpts that we played. But I think
it was a full day. It was an entire day of cross.
Yeah, but these two excerpts are excellent examples of the two principles or two types of cross-examination we were talking about. One, eliciting helpful information that you're going to use to support your theory of the case. And then the second, impeachment or attacking the credibility of the witness to argue that the jury or the judge should not believe the witness.
As to the leeway that the judge gave me here, and that I think is often the case, first of all, there's a big difference between a jury trial and a judge trial. sometimes we do have trials where the judge is deciding the case here. And in those cases, for example, in this cross-examination, I would have been much more compact because I know the judge would have gotten my point quicker, and I wouldn't have felt a need to dwell on it the way I did here. But with a jury, I did feel the need to make it as dramatic as I could, and I wanted to expand it as much as I could because it was such a central point to my case. Both aspects, both the helpful aspects and the harmful impeachment were so central that I wanted the jury to hear it kind of over and over again, but in a slightly different way. So it was very important to me to be that repetitious with the jury, but the judge would not have allowed me to do it if it were a judge trial. But as to the jury trials, I think most judges here believe that the defense lawyer should be given wide latitude in cross-examination, and they're hesitant to interfere with what the defense lawyer thinks is the proper approach. And there is a point where the judge will interfere. The government objects, and sometimes the judge will sustain it. So you can't go too overboard. But I think generally the mindset of the judge is to allow the defense lawyer a fair amount of leeway in cross-examining before a jury.
So I generally agree with that. I mean, I think the difference between a bench trial and a jury trial explains much of the issue with respect to how much leeway a defense lawyer has. I will say that there are some judges who do cut off lawyers on cross-examination and do interfere and would not, maybe even on Larry's questioning, would not give as much leeway to the lawyer to ask what you might perceive as repetitive questions, and even without an objection from the prosecution will jump in on their own and say, move along, counselor, move along. It really depends on the judge. It depends on how they perceive the trial going. It depends on all sorts of things that are sort of hard to quantify, but judges do interfere. And in fact, look, but the issue is that if they interfere too much and they limit the scope of questioning, on appeal, the defense will complain that the judge violated their right to confront the witnesses, that they violated the confrontation clause. And so, that goes back to sort of the first principle that we discussed at the outset, that we have a right, the defense has a right to confront the witnesses against them. And if you're somehow hampered in your questioning, limited in your questioning, either on the topics you're allowed to question about or the extent to which you're allowed to question, then you may have a claim that you were somehow denied your right to confront your witnesses against you. So it varies really courtroom to courtroom.
Yeah, but it's part of the reason why, as a defense lawyer, you need to know your judge. You need to know the judge's reputation, and some judges are much more flexible in what they'll allow than others. And in terms of this cross-examination, this was actually a wonderful judge in the Southern District of New York, but number one, this trial went on for 5 months. So by the time I was doing this cross-examination, I knew her practices inside and out. And I knew she was a judge who did not interfere with a defense lawyer's cross-examination. She took a very laid-back approach to that particular issue. So if it had been a different judge, I wouldn't have wanted to try the judge's patience if I knew that the judge was more likely to cut me off. I would have cut myself off first to avoid looking bad in front of the jury.
We all like to think of ourselves as logical decision makers, that we only use our reason to make decisions, and other people maybe are swayed by emotion. But in fact, all of us are swayed both by logic and emotion. So of course we didn't have the direct examination, but I imagine if we saw the direct examination, you would see the witness admit that he committed perjury to the SEC and admit that he participated in 30 years of fraud, and he would do so in a very dry manner. So the facts would come out, but they wouldn't have very much emotional impact. And so part of what the cross-examination does is to really get the jury to understand in a not just a cerebral way, but in a visceral way, to really understand in their gut that the person they're being asked to believe is a lifelong liar. And you can know that intellectually, but not be swayed by it as much as if you feel it emotionally. And so I think the effectiveness of a cross-examination that Larry demonstrated it really drives the point home. Second point I want to make is, because it's a demonstration and not a video of the actual testimony, you're not seeing the reaction of the witness to Larry's questions. And I know that we sometimes, you can draw different inferences from the demeanor of a witness, but there is a certain dynamic of an actual trial where you see how the witness answers the questions of the prosecutor, and you see how the witness answers the questions of the defense lawyer. And from the transcript, it appears that Mr. DePasquale was a very well-prepared witness and didn't fight too much on admitting bad things that he had done. But often that comes across in the actual testimony. And I believe, well, it's hard to know, that jurors and sometimes judges reach judgments about the credibility of witnesses in part by how they handle these questions. So while it's true, we can put the objective facts in front of the jury or the judge. Yes, this person committed perjury, and yes, they lied for many years. But as we mentioned in one of the earlier sessions, the rules of evidence in the United States are for a dynamic process. And it's through that live testimony that people form important impressions. And just the last point, in this case, as Larry said, that his client was convicted and the government asked for a 14-year sentence. I'm sure he was facing a potential sentence that was much greater even than 14 years. So the stakes are extremely high. And to make sure that the outcome is fair, defense lawyers are given a lot of opportunities to challenge the government's evidence. So I think that's part of the reason why in our system, cross-examination, even though it can be repetitive, is allowed to go on.